I also want to thank the Association of Young Legal Historians for asking me back, and also the University of Tel Aviv for having me here. Last night when I composed these slides at 30,000 feet, it struck me also I was very lucky to be here, because I said, we're going to have people from lots of jurisdictions here. Who's going to be interested in Scotland? Why, right? So what I want to do is give you a wee bit of a sales pitch. You might call it that, but also it might reveal to you a bit of what I'm trying to do with this otherwise micro-study. So, first of all, whenever we're talking about Scottish legal history, one of the things we always tell people, we are a mixed jurisdiction in Scotland. And we say, we are a mix of civilian influence and common law influence. And that's fine, and that's a very interesting vein of work. Me, as someone who tries to do legal history, I think Scotland's even more interesting because we've got an unbroken chain of legal development. We have no civil code in Scotland. Our courts, to this day, will refer to 18th century texts, 17th century texts possibly. So there's something fascinating there about the narratives that are created in Scots law, the way we teach Scots law and the way we research it. But also there's some very interesting thematic things that you can do with Scottish legal history and looking at the jurisdiction of Scotland. And one of them is law and religion. Scotland went through a seismic change which had an enormous impact on Scotland, which was the Reformation, which I think we've all heard of. Now in Scotland, that happened in two stages, in the 16th century and the 17th century. Kings' heads were chopped off and the papal jurisdiction was kicked out. Lots happened, but yet in Scotland we're still just at the fringes of even understanding how legal development related to these seismic changes in religion and the society of Scotland. And the other thing is that the period I'm working in is at the cusp of what you might call a law and enlightenment period. And again, when Scots go abroad, we always talk about Adam Smith and David Hume and the great philosophers. That's all fine. But there is something very interesting to be done in Scotland with regards to how the law related to what was going on in the moral philosophy of Scotland at that period. So the last thing that I'm particularly interested in is a micro-study of how law and ideas interact. We're all familiar, I think, with grand theories in histories of contract law, your Patrick Attias or your James Gordley's. That stuff is fascinating and I enjoy it greatly, but I am inadequate. I cannot do anything like that. So I try and stick to a small period of time. It's tempting to do more, but I think we can learn a lot and yield a lot from doing smaller focused studies into particular jurisdictions and actually understand how ideas and legal development happen. Okay, sales pitch over. Hope we're all interested. Right, so let me tell you a wee bit about James Dalrymple. He taught philosophy at Glasgow University in the 1640s. He entered the Scottish legal profession in 1646. He entered the big stage in 1649 because that date's significant because that was when Charles I got his head chopped off. Yes. Now, what happened in Scotland, and I'm not going to go into all the detail of this, but what happened in Scotland was the radicals got hold of the Parliament. You don't hear this phrase often, it always makes me chuckle, but the radical Presbyterians got a hold of the Parliament. And what was happening there was a real drive in Scotland for godly rule. There's a real fusion of theology and an idea of creating some sort of theocracy in Scotland. The laws that were passed by that 1649 Parliament are fascinating to look through. Sometimes in history we can look back and be quite unkind on what they're doing, but they were meddling in a lot of details of people's lives. This was real legislating of morality So it's called the Radical Parliament. And this is when James Dalrymple steps onto the stage, because he was asked by that Parliament, along with other judges, to do a review of Scots law. The Act of Parliament that was passed in 1649 uses phrases like zealously seeking godly rule, in great need of reformation of the law. It was not unusual for Parliament in Scotland to want to reform the law. We just never do it. But what happened at that time, the language had changed, there was an urgency, and what Parliament was talking about was godly rule. And James Dalrymple, along with others, was asked to do a review of Scots law in light of this request. Unfortunately, or fortunately for him, he was called away at that point over to Holland to do a negotiation with Charles II, or to be. So what happened was, in his mind at that point, this is one of the arguments that I've made in my earlier work that I'm doing with my PhD, is that in his mind, when he was drafting this work in 1662, he had in mind what he'd been asked by the Parliament in 1649. He'd started to draft something that would answer the calls for godly rule in Scotland, calls from Protestant Calvinists who were looking for godly rule. So we think that he probably started drafting his manuscript in 1659, the winter of 1659. Again, a very historically significant date, but we'll leave it for now. And what you find in this text is fascinating. It was copied, so we've got copies left. We've got about 20 copies left of the original manuscript. And what you've got here is, if you look at this slide, he says, from obediential obligations flowing from the will of God, order leads us next to conventional obligations arising from the will of man. And I want to just go on to point 2 that I've highlighted here. He said, once you've entered into a conventional obligation, by which he means contracts and promises and a few other detailed parts, but contracts and promises, he's saying here, God obliges performance by mediation of our will. So when you will a promise, or when you will a contract into being, you're not just taking an obligation to the other party, you are entering into a sacred thing with God. Now, this was a real fusion with Stair, and I've spent a long time thinking about this, and what I've had to do is go back and look at the law before Stair. And what you have before Stair is a very complex system of law. Before he wrote this, it was very complex. You had multi-layers of jurisdictions. You had your canon law courts, you had your borough courts, you had a centralised court in Scotland, but there was a lot of different jurisdictions and a lot of different laws. And the most influential form of contractual thought, you might say, was civilian. Your classic corpus ius civilis, your Justinian's institutes, lawyers breathed that in Scotland. They were always studying it abroad. It was what they did. So if there was anything from this complex system before Stair, it was a Roman law way of looking at things, of dividing contracts into 4 things and not theorising about it. But what we have in Stair, when he sat down to look at this system, he fused all these jurisdictions together, from canon law to customary law to civil law that was being applied, and he came up with a general notion of contract. He was talking about a general notion, not your singular Roman law approach. But he didn't just stop there. What he did there in this text, and as he goes through contract, is he introduces a theory of human action, which places the will as a central action in the creation of a voluntary obligation. What he's doing there is he's borrowing concepts from St. Thomas Aquinas. I'm not going to get into whether it was late scholastics or what, but he's borrowing from a scholastic tradition. He was familiar with this. He had taught it at Glasgow University. So when he sat down to look at the law, what he did was he pulled upon that intellectual universe of Thomism. And I hope we all know now that Protestants didn't mind using scholastic sources. Protestants in this period were very happy to do this. But this is interesting. No lawyer had done anything like this in Scotland. But the other layer that we have here is a theistic moralisation of the law. We should perform contracts because it's part of the natural law ordained by God. So from a political philosophy point of view, what Stair was saying there, and this was subtle to us, but at the period he was writing is significant. He was saying the system was to be administered by the king. The king was to administer natural law. The king was not to endorse it and say, this is the law that we will apply. So you can see his Presbyterian responses, the Puritan responses to your Episcopalian debates and such like in Scotland at that time. Whew. Are we keeping up? Right. A lot of theology here, a lot of talk about God. Sir George Mackenzie. In Scotland, we talk about him on the Wikipedia page as Bloody Mackenzie, which is an absolute travesty upon the man. But he was involved, once you had the Restoration and the royal family was reinstated in Scotland, George Mackenzie was a Lord Advocate. He put quite a few people on the scaffold, and as history was written in the 19th century, it was unfair on him. But he was actually someone who I would describe, and the literature on this topic has really brought out that he was coming from a humanist, virtuous sort of look at the law, and he produced a text in 1663 called The Religious Stoic, and he's talking back into the 1650s and 1640s. Now, this guy's a lawyer. Now, this made me laugh when I saw this, and I might share it with you. But if we think of this 1649 Parliament, Mackenzie says in this text, he says, "And I am of the opinion there are those who think that they have a church within their own breast, but they should likewise believe their heads are steeples, and so we should provide them with bells." Now, that's in his preface, but he calls for lawyers, and is part of the tradition in Scotland that he's part of, is that lawyers should be what I would describe as gentlemanly, but of civic virtues, similar to what we were just speaking about there, of the approach. So we've got 1663, we've got Stair's manuscripts circulating. Whether I can correlate a link between this and that, I don't know, but he's talking to people who try and moralise about the law. And in this text, he also speaks about lawyers and people who created the law as being too amenable to the radicals. The other side of Mackenzie's humanism, though, is he doesn't kick God out of it. What he does is he says, and this is from a wee bit later on, but there's a lot of texts in Scotland that say a similar thing. He thinks that civil law was divinely ordained by God. That's what he says, divinely ordained. We've got it here. So we've got this broader context, but in the background to this is that Stair has downplayed civil law. When he's talking about contract law, Stair is very, very unhappy with the idea of dividing things. He's very critical. Mackenzie's responding throughout his career to that sort of criticism, and he's trying to reinstate a civilian way of looking at the law, but particularly from my perspective, contracts and promises. So this is what Mackenzie did. He published his own textbook. So Stair brought that manuscript to publication in 1681. So that text that we've looked at and I've spoken, 1681, that comes to fruition. 3 years later, Mackenzie produces his own. Mackenzie's treatment of contract here is classic. It's based on Justinian's institutes. There's no will theory. There's no mention of God. There's mention of God at the start, but it's almost perfunctory. But it's very grounded, very humanistic approach to the law at this time. And his treatment of contract is not generalised. So he's if we're talking about the reception of the will theory, Mackenzie says no. And there's been a bit of work that's saying that actually Mackenzie directly responded to Stair. He wanted to correct the wrongs that was in that text. So, rival of the books, who won? So, I'll not run through all of these editions, but you can tell it was popular not only with publishers, but those who taught law in Scotland. And as I'll come on to say, lawyers in Scotland adopted this as their text to teach students. So reception of the will theory to how we're teaching lawyers, it's not here. I'll not dwell on that, but you wish you could write a textbook like that, don't you? That would get lots and lots. This is when I bring out a thread that Stair's approach to contract law wasn't completely rejected, I think, however. Because when this chap, Bain, he was the first professor of Scots law. His principal text was Mackenzie's institutions, which is based really on the Justinian approach to contract, right? But what he did, this Bain, who was teaching in the 1720s, what he did was he attached an appendix of notes to his students, and he also attached to another text a discourse which explained to his students not only how to study law, but also the development of Scottish legal history, actually. And one of the things he brings out clearly to his students in these texts, so we've got Mackenzie up on one side, but he's telling his students, actually, customary law and statute do change this classical system of civil law that we apply. So he's starting to bring in the idea that students also need to be taught about the municipal law, which changes the classic structure that they're finding in Mackenzie. And I've not quoted it here. He tells his students that to supplement Mackenzie, he will use Stair. But he does not use Stair in the same way as a moral philosopher would use it. He uses Stair to talk about particular rules, because Stair's book was over 600 pages, whereas Mackenzie's was about 133. And Stair actually, I've given a really theological taint to Stair, but actually he did a lot. When you go through it, he does report the law. This isn't just a book on theology. Far from it, there's a lot of law. But Bain doesn't reference that. It's just the law. I'm not going to bore you with this part, but there's a study in this paper that I've got where I go through each individual jurist that thereafter followed. And this pattern is repeated. The only person who does not follow that pattern is probably Bankton here in 1751. Bankton followed Stair. He used the term will, but he did not follow Stair's theology, far from it, but he did use the term will, and he spoke about contracts in a generalised way. But everyone else, they pretty much followed Mackenzie, but then said, when we talk about customary law, well, we can talk about common requisites of contracts. So there's something very funny going on here, an uneasiness about leaving behind the classic structure and now starting to talk about municipal law. And when they're doing that, they're echoing how Stair actually described the law. So that's the legal development of that. And I suppose where I got to is that there was a minor reception of how Stair actually described the law, but they understood it as him describing the municipal law, not contract law or promise law as a whole, but just how the customary law in Scotland was working and changing the civilian approach. But what happened to this big normative theory? How did Scotland respond to that? The idea that you shall perform your contract because you have taken out an obligation not to the other party but to God. How was that responded to in Scotland? Well, what I want to speak about is the moral philosophers that came after. And these moral philosophers were teaching law students at the same time. So, another big weighty bit of text here, but we've got Carmichael. And what Carmichael does is he speaks here, and just the highlighted text is he's teaching on the basis of Pufendorf's De Officio. He took that text and he gave it to his students and then supplied notes. So this is actually from Pufendorf, and it's endorsed by Carmichael as he's teaching his students. And what does he tell them? Why should you perform contracts? This is what he tells his law students. He says, and were it not an exact observance of one's promise absolutely necessary, no man could propose to himself with any certainty on whatever he designed, where he must depend upon the assistance of others. What we're starting to get here is a different explanation. We have contracts because they're good for society, they're good for commerce. It keeps us ticking along, not because we've made an obligation with God. He goes on, he's a bit tentative about this. He goes on and he does mention the sanctity of it, but he's moving towards what you might describe as a more secular, natural jurisprudence justification. And what do we have then? Hutcheson, who follows him. Hutcheson was the professor of moral philosophy at Glasgow after Carmichael. And how does he explain to his law students why you should perform an obligation? He says, since our perpetual commerce and mutual aids are absolutely necessary for the subsistence of mankind, not to speak of the conveniences of life that God has endued on men, not to without reason, but the powers of their speech. Anyway, what significant? He's placing first here that it's good for society, it's good for us as we live and cooperate first. Then he comes on to speak about God. So this is the natural jurisprudence developing here in Scotland. But it's very subtle, it's changing it just subtly. Actually, Hutcheson got pulled up in front of the assembly, the church. I'm rambling on now. But he got pulled up for potential heresies, so he was testing it out. So anyway, we'll go to Adam Smith. It's out with my historiography, but you can see by Adam Smith followed Hutcheson. Adam Smith followed him. And when you get to Adam Smith, there's no mention of God. And what he says is it appears evident that a bare declaration of will to do such or such a thing cannot produce an obligation. And then he says that the foundation of a contract is a reasonable expectation. Adam Smith teaches this to law students in probably even a bit earlier than that, but 1661. So reception of Stair's will theory was partial, very partial, which in Scottish historiography probably challenges the idea that Stair is one of our great jurists. He is, but to his contemporaries, no. And in fact, his theology was probably downplayed a great deal. We can see that. Okay, I've wrapped up.
Thank you very much. Questions?
First of all, fascinating. I think that I found another historical connection that might be interesting to you. Charles I was, when he was put to trial, one of the accusations was the violation of treaties, meaning between the first part of the Civil War and the second part of the Civil War. He violated the treaty of not initiating fighting again with the Parliament. Now, the theory of perfidy at the time in the law of war, which included a violation of truth, was exactly that. You are committing not only to your belligerent, but also to God. So I think there may be a connection there.
Well, this is actually something that I explored a lot in my earlier research, that if you know this period in history, you have the covenant that was made by Scots. At this time, and this is actually quite apt, Scots and the theology of the Scots in the 1640s thought that Scotland was a covenanted nation, thought that it was a new Israel. The theology that they were writing at that time was all based around Old Testament readings, and the theologians at that time would speak a lot in the 1640s. And then, yes, you have these sort of political glosses on these religious things where you have proclamations by Charles saying that he will respect the rights of the Church of Scotland, or proclamations by him that he will respect particular religious practices, and then constantly people saying that he was breaking his promises, and that being a justification. That goes into social contract theory that was in Scotland. But I actually have left that behind, because that's me building grand theories and biting off more than I can chew, and actually showing too much. You can't show direct correlation between the writers writing this and that social context. I'm tempted to, but yeah.
Well, it's a minor question of your opinion. So, do you think Mackenzie's work was more popular just because of its size and clarity? Because, well, judging by my experience, it was much easier to read than Stair's work and much more comprehensive.
I would disagree with you about how comprehensive it is. That was why Bain, the first professor of Scots law at Edinburgh University, that's why he said to his students, I'm going to use Stair, because there wasn't much, Mackenzie didn't mention much customary law, and he mentioned more legislation, which is back to his political theories as well. But yeah, but your general point's right. Mackenzie, probably to people at that time, was simple, familiar, and it was a good text to teach students. So I would definitely agree with that, and it was more manageable, but certainly lawyers felt they needed more than just the short text.
You can take questions for any of our speakers. Yeah.
So this is a question about the theological background of the wood theory. So I was wondering, do you see something similar in Massachusetts, in New England in the 17th century? Because if there was a theocracy in the 17th century, it's New England, and they have something called the Laws and Liberties in Massachusetts, which is a biblical code. So do you see the same thing there, or do you do it?
I'm aware of this, and I would like to do more, but I have not ventured that far yet. However, I think it's a very interesting area. As I say, with law and religion in Scotland, it's a very early area of research, which is actually bizarre in a sense, but we're few on the ground actually as sort of academics researching Scots law. So it's a worthwhile thing, and it would internationalise my research a bit, wouldn't it? It would add another element to it. So, yeah. But there is stuff with Miller's book, I think, The Puritan Mind, where he speaks a lot about narratives that I see reflected in Scotland at that time. Thank you.
I have questions for all of you.